Good afternoon, folks. I'm Charles van der Brouck. Welcome to another episode of The Future of Europe. EU citizenship, created by the Treaty of Maastricht in 1993, it is, in the words of the Court of Justice, destined to be the fundamental status of nationals of member states. But what does that mean for member state nationality? How does being an EU citizen affect being a national of an EU member state? Today, we discuss the relationship between member state nationality and EU citizenship in the light of the Court of Justice of the European Union's recent case, case C689/21 XV, the Danish Ministry of Immigration and Integration. And here to tell us about this is our analyst, Adrien Meyer. Good afternoon, Adrien.
Good afternoon, Charles.
So, Adrien, what's this whole business with EU citizenship?
Well, Charles, let's start with the basics. You're a citizen of an EU member state, right?
Absolutely, I am.
Yeah, well, me too. And as citizens of EU member states, we are also EU citizens. In fact, all citizens of all EU member states have EU citizenship.
Right, thank you. And how does EU citizenship fit in the picture, legally speaking? What role did the European communities, now the European Union, play? And what is left to the member states?
So first of all, EU citizenship is a legal link between a person and the EU. It's not exactly the same as nationality in the sense that you don't become a dual citizen or a dual national. In fact, EU citizenship is in addition to your nationality. With EU citizenship, we have additional rights. For example, an EU citizen can live and reside freely throughout the European Union. You can stand and vote in municipal elections, and you can also vote in the upcoming European Parliament elections from the 6th to 9th of June. Use your vote. Now, when it comes to the origins more of EU nationality and the way it structures within the treaties, EU citizenship was first proposed in what would become the Treaty of Maastricht back in the 1990s. Europe at the time was changing, was shifting gears. It was going from a purely economic union with the customs union, with the single market, to a more political one. The Treaty of Maastricht introduced several measures that included, for example, a monetary union, the common foreign security policy, cooperation in home and judicial affairs, and EU citizenship. Now, EU citizenship was seen as a symbol. It was seen as a way to attach citizens of the member states to what would become the European Union. But not all member states at the time were fully on board with this movement. In fact, in June 1992, Denmark rejected the Treaty of Maastricht in a referendum, 50.7% of the Danish people voting no. Back then, it was fears, of course, of the prospect of United States of Europe, for example. And it's only with the European Council meeting in Edinburgh that they reached an agreement where, in this agreement, they would set certain exceptions and opt-outs for Denmark. Now, the important one here for us is the opt-out when it came to, or the rectification when it came to EU citizenship. They placed in this declaration, in this decision, said that EU citizenship does not replace nationality. The question whether an individual possesses the nationality of a member state will be settled solely by reference to the national law of a member state. Now, this language was generalized to the rest of the EU with the Treaty of Amsterdam, which came into force in 1999. So this rule about nationality applies to all EU member states now. So the basic idea is the rules of acquisition and loss of nationality remain solely in the hands of EU member states.
We can agree that this has sort of changed, though, recently, right?
Yes, there has been an evolution because since the Maastricht Treaty, the status of EU citizenship has evolved. What was initially more of a political, symbolic element now has quite large consequences, as EU citizenship does grant rights to EU citizens. And so the court found itself at the beginning in the case Rotman with the question, well, if you can lose your nationality and therefore your EU citizenship, when it comes to the questions of loss of nationality, should this be done solely by reference, of course, to national law, as it says in the text, or should you take into account the consequences of the loss with regards to EU law? Now, the court said here, and this was quite interesting, the court said that, yes, the competence remains in the hands of the member states, but when it comes to the loss and acquisition of nationality, this must be exercised having due regard to EU law. It went further than that, in fact, because Rotman was an individual case. In the case Tjebs and others, the court examined a law in the Netherlands where it said that if after 10 years if you have not expressed a certain link with the Netherlands, you can lose your Dutch nationality. After these 10 years, of course, if you're a dual national. And so the court there said that when it came to this loss of nationality by operation of law, you must also have due regard to EU law. And finally, in this case, Wiener Landesregierung, the court said that any of these decisions must not only be done with regards to EU law, but also the rights given by the Charter. So what are the consequences of this? It means that although before we had a system where it was only the states could decide how nationality was lost or gained, now the court has the right to examine whether those rules are respecting the EU law. And that's what brings us now to the present case.
Can you tell us a bit more about this present case? What exactly happened?
So in this case, X versus the Danish Ministry of Immigration and Integration, X is a young woman born in the United States to a Danish mother and an American father. Now, she is Danish nationality through her Danish mother. And Danish nationality says that, law says that Danish nationals who are dual nationals born outside of Denmark lose their nationality by operation of law upon reaching the age of 22 if they have not proved by that date that they have a genuine link with the Kingdom of Denmark. Now, in this case, she had applied to retain her citizenship just after turning 22 in 2014. And having missed the deadline for applying, well, she automatically lost her citizenship pursuant to the law on Danish nationality. And as she was not a citizen of another member state, she was an American citizen, she also lost her EU citizenship. Now, of course, in light of the case law that we've seen through Rotman and Tjebs, any loss of EU citizenship, or actually the member state nationality, must be done with regard to EU law. Now, the Integration Ministry said that they did take into account, of course, EU law, but that she hadn't managed to prove that she had a genuine link with Denmark, and that as she had brought this action only after her reaching the age of 22, well, she inevitably lost her nationality.
And what did the court have to say about this?
Well, as Advocate General Spuznar said, this case was the perfect opportunity for the court to take its previous case law and apply it here. Now, we need to keep in mind that the Danish authorities hadn't just ignored the court's previous case law. They had taken into account Rotman and Tjebs, and they had said that when a person has their case reviewed by the Danish authorities, this case is reviewed in light of the consequences of losing the EU citizenship, and therefore in light of EU law. Now, the court here had to examine this new legislation, the legislation rewritten after Tjebs, using its criteria. There are two criteria here that the court has looked at. The first one is whether the legislation pursues legitimate aims. Now, the court had specifically stated that it is legitimate for a member state to wish to protect a special relationship of solidarity and good faith between its nationals, and also the reciprocity of rights and duties, which form the bedrock of the bond of nationality. It's a question of genuine link. Now, we can, of course, question whether a genuine link, what does it really mean, what is its value, but ever since the Nottebohm case from the International Court of Justice, this has been pretty much the benchmark for what is a link between states. Now, the court here found that there was a legitimate aim and that the Danish legislation did pursue that aim. The real interesting question here is of proportionality. Now, there were two major difficulties here when it came to how the Danish law addressed this case. One, the Danish law didn't allow for every person's case to be reviewed, and that was one of the major criteria established in the Tjebs judgment. And two, the court found that as the people who could lose their nationality were not informed that they could lose their nationality and were not given a, let's say, long enough time to submit an application to retain nationality, this basically took away the effectiveness of this review in light of EU law. And the court here really put forward the principle of effectiveness, that you shouldn't just say in the law that you will review a person's situation in light of EU law. You must give every person the opportunity to have their situation reviewed by EU law and make sure that this is effectively done, the effet utile, as we like to say in EU law.
Could you, to conclude, could you tell us how it impacts the future of Europe?
So it impacts the future of Europe in two ways. One, it shows us that EU citizenship is, as the court is saying, becoming more and more what may be one day the fundamental status of an EU national. We now have the possibility for a European institution to come and examine nationality laws. So that's one big part as to how EU nationalities and EU citizenship are going to evolve. The second part is, as we live in a world where there are more and more dual citizens and different states, for example France, certain political parties are advancing the idea of maybe reducing rules on dual nationality and making it stricter. Well, now any future legislation on dual nationality or on removing nationality for X or Y reasons they're going to have to take into account EU law, and they're going to have to take into account the principle of proportionality and the principle of effectiveness. And as we move forward and as we move into this more globalized world and as these questions are asked, the EU, whereas before the place of the EU was not specifically defined, now we have a specifically defined place of EU law in this question.
Thank you very much, Adrien. Folks, this was it for this week's show, Future of Europe. We will see you next week. Thank you very much.